This program is powered by AIM Employers Association and Ogletree Deacons, a Feature Group USA production.
Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association. On November 5th last year, Missouri voters passed Proposition A, approving mandatory paid sick leave, which began accruing on May 1st of this year. On July 10th, that law was repealed, effective August 28th. What's going on? What should you do now? Strap in. We're about to get fired up on This Week at Work.
This Week at Work is the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode.
We're going to have Missouri paid sick leave. And then our legislator said, no, now we're not going to have it, but we've already implemented it. We've already programmed our systems. We've made changes. And now that's going to go away in August. And now what do? Do we continue with the adjustments that we made, even though we did those for the purposes of compliance? What should I do with any time that's unused? Those are important questions to get right. We made changes again, and now we are taking away versus adding. That's a dangerous move that sparks emotion, and reaction follows emotion.
Download today's key takeaways and spark change in your workplace. All this and more on This Week at Work.
Good morning, Burt. Welcome back, buddy. It's been a while since you've been on the program.
It has been a good couple weeks, Phil. Man, it's I'm exhausted. I'm beat.
Yeah, a little bit of summer heat or summer work.
Summer work. I've been in trial the last 2 weeks, and it was grueling. A large trade secrets and non-compete case that I'm defending, and it's been a good couple weeks, solid couple weeks, and we're on the home stretch. We have a couple days that we have to do to finish this thing up in likely in September, but the light is at the end of the tunnel there.
No, that's good. I know you've been working hard for your client and doing a good job as always. I can appreciate that, and I hope it goes your way as you finish things up approach through September. But maybe you get a chance to take a breath. I want to bring up
maybe.
Yeah, we've had a good run while you were out. We had AI and HR Week. We introduced Amy Hart to the world, who has been doing a fantastic job. We've been getting some great feedback about her. That's AIM's HR assistant through ChatGPT. So we've been training her, and she's been doing a great job helping employees and our employers and HR professional, but mostly our members.
So is Amy Hart real, or is she virtual?
Amy Hart is virtual.
Okay, just making sure.
Yeah, but she gives you real answers.
All right.
So she's a great technology that I don't know. I've gotten some great feedback, and many of our listeners have been bragging about her as well. Been fantastic. So there, Bert, you can see on the screen there. There's Amy Hart. Clever naming convention, and really it's been nothing but positive feedback so far. You do have to be careful. I mean, it is a chat GPT, and it comes with all the cautions of that. So if you haven't tried Amy Hart yet, get out there and give her a try, and let us know what you think. But I want to bring up something I ran across yesterday. It's quite interesting. And you and I have talked a lot about working from home and remote work. And, AIM is involved in hiring processes and background checks and all kinds of onboarding responsibilities for employers and, everything that just comes in that employment cycle. And so I'll call to your attention here, and you can see the headline is "Man in Prison Gets Full-Time Job as Software Engineer at Silicon Valley Startup, Works Every Day from His Cell." And it shows a man in prison working on his computer cell. So this is a whole new concept of working from home or working remotely. And I don't know, have you ever heard of this? Apparently, this is a program they have in Maine that isn't all that uncommon. There's more than this individual who works remotely from their prison cell.
I have not heard of this. I mean, I think it gives new meaning to being like chained to your job, but we know where we certainly know where the person is.
Yeah, well, that's for sure. But just imagine, and I guess as a software engineer, I don't know what kind of confidential information you're having, but I'm assuming the design of the software itself would be important to protect. How you're putting security controls in the prison, right? Because I'm sure the prison's watching everything coming in and out. But I'm thinking about the background check. You get the application, you find out the individual's residence is at a state penitentiary, and you get a background check, and it's not just have I been convicted of a felon and why, and is it okay still to employ the person? It's like I am still serving my sentence as a felon in prison. It's quite interesting.
It is
But
very
maybe,
interesting.
not bad though, right? I mean, like rehabilitation and other things. And he learned a skill of engineering while he was in prison.
Hmm.
Yeah, so
Impressive. Good
that's
for
good
him.
rehab.
Yeah.
That's good
Well,
rehab.
Is
my
this
question is, so
is this
like,
the real guy?
I don't know, that
I
looks
don't know if
AI.
that's his real picture or not.
Ah,
I would just say,
Yeah,
so what are people just chilling in prison, just searching the web and like, you know what, I think I'll be a software engineer. So they figure out how to do that, and they're like, you know what, I think I'll go to LinkedIn and see what kind of opportunities I can have. How does this connection happen, right?
Yeah, I'm not real sure of how the connection happened. I researched it to make sure it was factual, and I got that. I tried to get an idea of the salary. There wasn't really anything that was available about the salary other than some people have raised their eyebrows like in fashion of that's a lot that he's making for himself while he was in prison. But then there's more information just around the state and the program and how it does help people rehab. And I think I'm probably all in favor of those things. That's better than sitting there playing bridge or something with your other inmates and in a
is
car
that
every
what
day.
happens in prison, Phil?
I don't know.
Oh,
I don't
okay.
know, Bert. We're going to change the topics now, since you're going to go down that aisle. But yeah, I have no idea. I just thought this is a really good one and stretches the concept of working from home and background checks and felonies and other things that we all worry about when we hire people to work for us.
This segment brought
Quite
to you by
interesting.
Guile.
All right.
We're gonna get letters on that one, Phil.
Yeah. All right, Bert. So we got a lot going on around here. Obviously, there's a major focus for AIM this month as we're getting ready and talking a lot about compliance and getting ready for our employment law update that's coming up. And you are going to be facilitating the Missouri portion of that law. And in Missouri, we have quite an issue with Missouri Proposition A. And with Prop A, I'm getting an echo here, Mick.
Tim
Mick,
needs to mute. There we go.
there we go. All right. So on Prop A, we did a lot of work. We did a lot of work getting everyone ready for Prop A with the idea that we knew this might change and get repealed. And it has. And now, Bert, the questions are coming in for us. I'm assuming they are for you. What do I do now on several fronts? And really does, start taking a path of its own. So I want to get into Missouri Prop A right after we get into Lawyer on the Clock. Are you ready for that, Bert?
Barely, but yes.
Barely, but yes. Well, you give us what you got, and then we'll finish it off with Prop A. Nick, let's go ahead and pull that lever.
Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, I've been out the last couple weeks, but the news, of course, has not stopped on the federal level. And we all know that one of the main focuses of the Trump administration is sort of they've really have been focused on
On the Epstein file?
kind of repealing the whole LGBTQIA plus agenda, trans issues in the workplace. The administration kind of markets this as a return to sanity. I'm not making commentary on that one way or another. But the other side of the coin there is that you have a lot of people fighting back and a lot of groups fighting back. And just 2 days ago, a Maryland-based LGBTQIA plus advocacy organization filed suit against the United States EEOC, the Equal Employment Opportunity Commission, to walk back enforcement of protection, challenging the EEOC's effort to walk back enforcement of protections against sexual orientation and gender identity discrimination on the federal level.
So what does that
And
mean to walk back enforcement?
well, the EEOC is trying to walk back enforcement. They are saying we're no longer going to enforce these protections. And this group is suing, saying that yes, you still have to try to
I see.
enforce these things.
Okay, I got you. Yeah.
And so this group has basically filed a 41-page lawsuit and said that the actions that the EEOC has taken, which the group has dubbed the agency's trans exclusion policy, runs afoul of Title VII of the Civil Rights Act, the Equal Protection Clause of the Constitution, as well as the Administrative Procedures Act. And so there are a lot of legal challenges to this. Now, I've been kind of predicting on the program for a while that ever since the Supreme Court's decision a couple of years ago in the case of Bostock, where the Supreme Court said, and I think they rightfully did say, that transgenderism, sexual orientation is already protected under Title VII of the Civil Rights Act of 1964, that employers cannot discriminate against people based on their gender status or their sexual orientation. And I think the Supreme Court absolutely got that decision right. But what they've done with that decision is they've set up a battle that's going to come to a head eventually between people certainly on the religious side, is they say that certain efforts, transgender efforts and sexual orientation go against the religious grounds. There is going to be a battle between the religious grounds and the LGBTQIA plus protections, in my opinion, that's gonna come to a head in the workplace. So I think what you're seeing these groups fighting back as the Trump administration tries to unwind a lot of what was done under the Biden administration in this area. Religion is one area where this is definitely setting up for a battle down the road. I just kind of want to keep this on everyone's radar.
Yeah, that will be one we'll definitely watch and keep our eye on as it develops.
In another effort, this one I do think hopefully most people can rally around this one, is that the United States Department of Labor has brought back its self-audit paid PAID program that allows employers to identify and resolve Fair Labor Standards Act and FMLA violations, kind of switching from the last 4 years under the Biden administration, where the Department of Labor kind of would play gotcha with employers, trying to catch employers, sue employers, and almost sort of aid employees as they would bring private rights of action as well. Now the Department of Labor has reinstated what's called the PAID program, which is the Payroll Audit Independent Determination Program. And what this allows is basically employers to self-identify and resolve minimum wage and overtime violations under the FLSA and certain leave violations under the Family and Medical Leave Act. This was initially launched by the Wage and Hour Division in April 2018 as a 6-month nationwide pilot under the first Trump administration. And the idea was to facilitate resolution of potential violations without litigation and ensure employees promptly receive the wages that they're owed under the FLSA.
So is this I've been caught doing something wrong by the Department of Labor or someone, and therefore I can go rectify that using this process? Or is this, we discovered we're doing something wrong, we didn't know it, and we want to make it better, but the Department of Labor otherwise has no awareness other than we self-disclose?
Yeah, the second your
The
second
latter? Okay.
description, it's so it's a voluntary program where when you are looking at your pay practices and you discover that you've been doing something improper, it might be something like off the clock work or
Okay.
not paying the regular rate of pay,
Or
time and a half
bonuses
the
and those
regular rate of
types of things. Yeah.
time and a half the regular rate of pay for overtime or something like that, and you discover that you've been doing something wrong. This allows you to go to the Department of Labor and work with the Department of Labor to rectify the situation without the need for litigation, either by the Department of Labor or a private right of action. So it really does signify a big shift in the Department of Labor's priorities under the Trump administration as compared to the Biden administration. And so while this program is in effect, if you are an employer that has any questionable wage and hour practices, or if you simply just don't know, now is a really, really good time to do an audit of your practices, figure out if there's things that you're doing improperly, and then working with the Department of Labor to get this rectified so that you can avoid litigation down the road, especially if the administration changes in 3.5 years. Again, not making commentary one way or the other, but you want to try to get this stuff rectified.
Well, you got a window of collaboration here. Yeah. Okay, good.
Exactly.
Yeah. Well, when you're talking about pay and I got to get into Proposition A because it did have an element of pay as well. You ready to move on to Prop A?
Yeah, let's talk about Prop A, Phil. What can I tell you?
Well, I'm just going to ask you the questions people are asking me. So I'm going to just start with what is changing about the legislation with Prop A. There's really two elements of it, if I frame it that way. There's the element of minimum wage, and there's the element of paid sick leave. And I think we can put minimum wage and what that pay requirement is. That's relatively easy, I guess. In Jane, nothing's changed in that. We will still progress to $15 an hour. We're talking about Missouri specific law here, but that progresses to $15 an hour January of next year. And then there was an escalator on cost of living after that, and that's been put to rest. That's not going to stay in effect, as I understand it. So that's my first question to you. Is that what you also understand?
Well, so Prop A, of course, like you said, raised the state's minimum wage as of January 1, 2025. And House Bill 567, which was the repeal bill that Governor Keogh signed into law, repeals the paid sick time statute, but it also amends the minimum wage statute to eliminate the cost of living increase that was built into future years.
Right. Okay. When it says it eliminates that, that's the cost of living, but it does allow then, we still will go to $15 an hour on January 1, 2026.
That's right. But that escalator in subsequent years has been removed.
Okay. So that piece is easy. I think the more difficult piece is what do we do now, right? So we've gone through the process. You and I, Melissa, our teams have helped employers implement a process that would be compliant with Prop A. And now that that's been repealed, I guess it's on August 28th, I think is the date, or 27th. That will no longer be in effect. And this means employers can go back to their old practice. They can develop a new practice. And what do I do between now and then are the questions. Those are the three core questions. But the knockout question for me, Burt, is what if I haven't done anything? What should I do today?
So if you haven't done anything, what should you do today? That's a really good question,
And
Phil.
I do have people going, oh, I didn't know. What should I do? Yeah.
So technically, yes, I like the flame there, Nick. Somebody who runs the risk of getting burned in the next 27, 28 days here. So if you haven't done anything, I mean, technically, you are supposed to be allowing employees to earn paid sick time as of May 1, 2025 through August 27, 2025, and they're allowed to take that time as they earn it. So they earn 1 hour paid sick time for every 30 hours worked. And again, that time is immediately available. If you haven't been doing that, you owe that to the employees.
And
And
that's still
so
enforceable.
it is.
Whether it
It
would
is.
be or not, we don't know, but it is still technically the law.
Yeah, it is technically the law, but word that I am hearing from Jeff City is that the Missouri Department of Labor is not going to be enforcing any of this. You still run the risk of a lawsuit,
Yeah.
but it's probably not going to be a very profitable lawsuit for any plaintiff's attorney who takes this on because there's just simply not that much time involved. I guess maybe if they tried to bring it as a class action, if you have broadly deprived employees of this leave during this interim period, maybe it has some appeal to a lawyer, but it's again, you have to follow the law. But if you don't follow the law during this May to August period, it's probably fairly low risk at this
Yeah.
point.
So employers are going to have to make that determination based
Correct.
upon measuring the risk and where they sit today, and the cost to implement or make adjustments. And I know we've been helping a few people kind of navigate that, and that's really where they've been netting out. And really, I've seen most people are just communicating, sharing what is available, eliminating the risk. It's not that much on either side of, time earned plus, uh, you know, the risk. It's just easy enough. They've been making pretty simple decisions for their business. But if you do have questions, I'm happy. I know Burt would be happy to talk through those things with you. But all right, let's talk about what happens when August 28th comes along and people have accrued sick time based upon the implementation back in May, and now they want to use that paid sick time on August 28th.
So,
Um,
so Phil,
yeah.
just humor me for a second. So cover your eyes really, really tightly so that you can't see any light coming through. And
Okay.
all right, and now what do you see, Phil?
Nothing.
Exactly. After August 28th, nothing. They
Okay.
that's it. No more. There is no more
I
paid
can
sick
tell
time.
you've been in trial, man. You got all these new little gimmicks that you're using.
Yeah, exactly. That's what I tried to tell the judge. Judge, what do you see there? Nothing. That's exactly
Yeah.
it. Uh, so yeah, after August 28th, that's it. There is no more paid sick time. And again, what I'm hearing out of Jeff City is that the Department of Labor and Industrial Relations is not going to be enforcing anything related to this law. The enforcement mechanism, all of it ends on August 28th with the repeal of the law. And so the Department of Labor has said that they're likely to issue some guidance for employers about how to phase out paid sick time, particularly whether employers must allow employees to continue to use that paid sick time that they earned but did not use under the policy that would end with the repeal of the law. But again, once this is done, this is done. And I'm pretty confident that that's the
Gonna
way
be put
employers
to
can
rest.
can
Yeah.
handle this. Now, I will tell you though, this effort is not dead. Missouri voters are going to have another opportunity to consider the issue of paid sick time in the November 2026 election. A ballot initiative has been filed that would provide a similar paid sick time benefit to Missouri employees with a few key changes, such as allowing an employer to avoid the carryover mandate by front loading a required paid sick time at the beginning of the year. That proposed new paid sick time law would take effect February 1 of 2027 if it's passed by the voters in November 2026. So the
Do you
effort
know
is
if
not
that
yet.
accrual rate is the same process of accrual 1 hour for every 30?
I have not studied the initiative
Okay.
yet, but I will be digging into that just to see what's been proposed. I think you can probably expect that there will be some tweaks to it before it actually gets voted on. We've got what a year and a year and 4 months before this appears on a ballot. So we'll see what happens.
Yeah, that'll make my head spin if it comes out and it's even more different. But it sounds like there's at least awareness now of some of the complications that really just made this a little bit unreasonable.
Yeah, and I am looking real quickly, Phil, as we're talking here, and the accrual rate does appear to be the same. So,
Yeah.
uh,
So I think that gives us a little bit insight then. If we think about um, what are really our options, in August, starting on the morning of the 28th, I guess. You can revert to your old policy if you preferred that, and you're doing a manual process of accruals. And some employers are doing that because they weren't able to program their systems quick enough. Or they knew we had line of sight that this might go away and they didn't want to invest in programming, and therefore they just did a manual process. You can revert back, and no harm, no foul then. But recognizing, should this go on, the accruals process looks at this point early stages without any adjustments or changes. It might be based on that same formula, 1 hour for every 30.
yeah,
You
had your members listened to me, and had my clients listened to me, and a lot of them did.
Well,
They
that
in,
sounds very fatherly like
they,
when you
they
say that. Now, if your members listen to me, now, if you would have listened to me, son.
Exactly. You would have implemented an interim paid sick leave policy rather than revamping all of your paid leave policies to work in harmony with the new paid sick leave law. You would have just implemented this interim policy, and you can unimplement the interim policy as quickly as
Yeah.
you implemented it. Because it was designed and I drafted it to be an interim policy with the understanding that this was going to get repealed and it was going to get signed by the governor and repeal this by August 28th. So I
And what you're
think
saying is my interim policy, I think. Yeah.
exactly. And I think what this does is in advance of the ballot initiative for November, again, I want to stress it, November 2026, not November 2025. But in light of this ballot initiative, and we'll have some idea in 2026 what this is starting to look like, and get some polling on all of this. I would say in 2026 it might be a good idea, especially toward the second half of the year, to start looking holistically at your company's leave policies to determine whether you want to implement something ahead of time, maybe to start February or January 1 of 2027 that might satisfy the new law. And then when the new law would take effect, assuming it gets passed, you're ready to roll. And you're ready to
Yeah.
roll on January 1 of 2027. So again, something I would maybe put on the HR agenda for the middle of next year. Good idea to sort of take a look at all of your leave policies. And again, you want to make sure that they're all working sort of in harmony. I keep using the word or the term holistically. Take a holistic look at your various leave policies to make sure that you are providing the benefit that is needed to attract and retain good talent, but also with making sure that your business can continue to operate at full capacity and be productive. Again, I just think next year is a good time to take a look at this stuff.
And that's a good segue, Burt, as we're bringing the program to a close. You can download the Ready Aim Fire Prop 8 cheat sheet by clicking, what do we click on there today, Nick, to do that?
Well, there's a link in the description if you're on LinkedIn or YouTube, or you can go to that QR code that's there on the screen.
Perfect. And also, Burt, you're going to be leading, we have a new format for our employment law update, and registration is opened for that. The format's quite impressive. So we've been doing the employment law update for 30-something plus years. And as we have grown as an association and the challenges of employers are continuing to be even more difficult every day to comply with, we're going to take a different approach. Burt, and you're a part of that in case you didn't know, and we appreciate your involvement. One is we will be doing a federal employment law update, and then you would get the choice of picking your state, and then there'll be a state local focus depending on what you're interested in, and we'll have participating lawyers from around the region in different states. And Burt, you will be doing the portion for Missouri, so thank you for volunteering to do that. And then if you're interested in part 2, we will have a policy workshop and coaching workshop that follows the employment law update, which we'll be focusing on very specific policies, and the intent there is very small groups, working sessions on specific policies as it relates to the upcoming changes. So don't wait, get online, register now. And Burt, anything else before we close?
No, I'm going to try and catch up on my sleep this week, Phil, and be a little bit more lively on the program next week.
I would call it your beauty sleep, but we're not going to go there. But we will be back next week at 7:30 Central Time. We'll see you then. Till then, go be good to somebody. Bye-bye.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today. Thank you once again for tuning in to This Week at Work. If you enjoy the show, please like it, share it, and make sure it's on your calendar every week. Ask your burning questions anytime and let us know what topics you'd like us to cover. Just go to hrask.org and be sure to leave a review wherever you catch our show to help other HR pros find us as well. We'll see you next week when we discuss what's happening this week at work.